So hi everyone, it's Bayo, CEO for Dr. Daisy Capital. And today we have another webinar for you guys. And we're going to be talking about asset protection. Unfortunately, our main guest, Lacey, she had an emergency and she will not be joining us. And thankfully, we do have some of her partners. We have Howard Berkson, and we have Isaiah Edison. And both of them, they're going to be giving us their own perspective. Howard is a litigation attorney, so, highly experienced in litigating companies. So you assume that individually, even with your own LLC, it's a company, and your assets, your estate, consider it to be like a company. So it's important to know how to, protect yourself. And also, Isaiah is a wealth advisor, and he helps his clients in wealth management and also advise them the best way to structure their estate in a way that would be the most beneficial. So I'm going to just introduce first Howard to introduce himself, and then Isaiah to give a quick introduction also, and then Howard will then go over the slides. Okay.
Very good.
Go ahead, Howard.
So my name's Howard Berkson. I'm a managing member at Boston Avenue Law, and Lacey is our estate planning expert. But I'm still qualified to talk to you about asset protection because I'm the guy that you're trying to protect your assets from, primarily a plaintiff's attorney. The issue with asset protection really doesn't come up until you get sued for something for which you are not covered by your insurance or for which you are simply not insured. So insurance is your first line of defense. After that, probably coming for your assets, and we'll talk about different ways that you can protect them today.
Okay, Isaiah.
Yeah, I'm Isaiah Edison, and I'm the founding partner and wealth advisor at Edison Wealth Strategies in Tulsa, Oklahoma. We have clients all over the country, and for over a decade, most of our clients are physicians. So we have a lot of practice working with physicians on estate planning, asset protection planning, things like that. We have a back office group of folks, about 30 different attorneys, CPAs, people like that really help us do what we do. And I know that a big part of this group's kind of all over the country. I'm understanding there's a lot of folks from different places, here. And a lot of these laws, as Howard will tell you, are so state specific that it's important that we have that kind of back office there and all. So pleasure to be here, and I'll kind of let Howard get started, then I'll jump in a little later.
Whoever figures out how to make the I.R.S. fall in love with them, let me know. Well, this is good. I like this. So, right, have no plan. One thing I can say about asset protection is once the event has happened that you're trying to protect yourself, it's too late. So, for example, if you put everything in a trust today, but you got sued 2 days ago, that trust is not going to protect you. So it's not only enough to have a plan, but you have to have a plan that you put in action sooner rather than later. Because once you've already been sued, once you're already behind on your taxes, once you already are having these problems, many of these plans can be undone very easily. Never update your plan. That's the other side of the coin. If you have a plan and you execute your plan, and then later you get married and buy a second house and have some investment properties, and you never update your plan, then you don't know if all the changes in your life have created exposure for you. And because I'm not Lacey, I don't know what HNW tax planning is.
High net worth.
Fantastic. So she says, forget about high net worth tax planning. I don't give tax advice, so I don't know if I'm comfortable saying forget about it, but what I can say, there are a variety of schemes I have clients that get involved in. Some of them are legitimate and seem to make sense. Some of them I go and talk to, I have 2 tax attorneys that I work with on these kinds of things. And I'm not prepared to say simply forget about high net worth tax planning, but I will say is beware of tax shelters. And if you're doing this kind of stuff and you don't have either a tax attorney or a CPA or a very knowledgeable and honest wealth planner working with you, there are a lot of tricks and traps in tax planning that will get you in trouble. There are solutions that will put you in jail.
And if you don't mind me jumping in real quick, I think what
Please do.
Lacey was kind of talking about here is so many folks will get a basic plan done, but then as their assets grow, they don't continue to work on asset protection strategies and estate planning strategies. And so that's what we're going to talk about today. Or don't forget to kind of build that next step plan. If you're, and I'll talk about this in a few minutes, but if your assets are to the point where you're pretty close to that estate tax exemption amount, you've got to do a ton more things. And so that's kind of what we're going to talk to you about is kind of the next step of planning.
What happens when I have no plan? Well, it depends on the threat. If the threat is me, I have a judgment against you when you have no plan. There's a very short list of things that I can't take from you. I can't take a house that you live in, but if you own one you don't live in, I can take that. If you have more than one car, I can take that. You got a boat, I can take that. Airplane, guns, watches, coins, furniture, even to a certain extent. Your business actually can be taken from you if it's a corporation, if it's an LLC. There's a debate about that, but I think the most settled opinion is it can't be taken from you, but it can be made so that you can't make money from it. So if you have no plan at all, then you don't have any protection, except to the extent you're insured. So as Lacey points out here, if you don't have an estate plan, the law has created one for you. And in this case, we're talking primarily about death. And if you die and you don't care what happens to your assets, that's fine. You're leaving a wake of problematic decisions for your family and a great deal of chaos behind you. But if you're dead, that's not your problem. But anything that you care about, what happens to it, grandma's cooking fork, even, it doesn't have to all be cash, but these things will be divided up without really even the heirs having any say. So as the states here, using the state's default laws, these are called the laws of intestacy. For death, there are other laws if you were to become disabled, but they're similar in that once the problem you have comes about, you're dead or you're disabled, then the state law comes into effect and starts deciding who gets to make decisions. So if you wanted your spouse to make decisions, but your spouse died and you didn't update your plan, or you had no plan, then whoever the court appoints, and they just go down a laundry list. If it's not your spouse, it could be your parents, it could be your siblings, it could be your children, it could be a stranger. So this is part of having the plan. The plan gives you control. If you're here, you probably know what probate is, but probate is the court that handles these matters. And so, for example, if you die and you don't own anything except a car, the car can't actually be given to anybody else except through a probate action. It's the same would be true for real estate, any kind of certificate of ownership asset, cars, boats, planes, etc. But they'll use, if you don't have a will, they'll use the intestacy laws to decide how your stuff gets divided up. And things that you might have planned to give to a specific person, like a house, might end up being sold and the money split up to jive with the laws of intestacy. So I don't know what she has this on there other than it's an example of a probate inventory. And somebody will be given authority to go and make a list of all the things that you have. But the purpose of that is for the court to divide it up according to the laws of intestacy, not so that they can sit down and make a deal among themselves, your family members. So Not everybody needs probate, but probably everybody here needs probate if you don't have a way around it. There are ways around every aspect of probate, but it goes back to having a plan. So for example, owning accounts or property in your name only. If you have a bank account in your name only, unless you sign a variety of kinds of different papers, one would be a pay on death certificate for the account. The money's never coming out of the account until you do a probate and the judge orders it. This can also happen with a will. If you don't have a will, you have to have probate for any of that kind of stuff. If you have a will, but you haven't kept it updated, or if it doesn't have a catch-all clause that deals with all remaining property you haven't otherwise mentioned, then your will won't be sufficient. And typically a will has to go through probate anyway. So most of the things we're going to talk about are ways to get around having to do probate, which aside from the fact that it means your property is going to be divided against your interest if you don't have a will, but if you do have a will, it's still going to be taxed, it's still going to be delayed, and it can still be challenged and not necessarily work the way you had intended. So this explains how intestacy works, and I don't know that we need to get into the details of that, but you can see, generally speaking, on the left side, we have different kinds of situations. If you die, who's left? Your spouse and kids, whatever. And then it tells you how it gets divided up on the other side. In our state, for example, if one of your children predeceases you, but they have children, then what that deceased child would have received is passed on to their children. And it can become pretty complicated if you have a lot of kids and they have a lot of kids and different people at different levels of the pyramid have died. But at the end of the day, they're going to figure out a way to put a number on everything you own and divide it up according to a table like this. Okay, avoiding probate. And this is where we get a little bit more into my space. The things that people do to avoid probate are also things people can do to protect their property. In some cases, there are risks. And in many cases, these things it's like a rock, scissor game. There isn't a perfect protection for everything. You're always going to give up something. You're going to give up some degree of control or some degree of protection. Typically, those are the two things in balance. So one way you're going to avoid probate is you can have all your assets in the name of an entity. And an entity, we're talking about a trust can act like a person, basically, just like a corporation or an LLC. For reasons we'll get into later, an LLC is a better vehicle than a corporation. Trusts, there are a lot of different varieties of trusts, but the big word that you need to be aware of is revocable versus irrevocable. And from an asset protection standpoint, if you have an irrevocable trust, those are much harder for me to stick my hands into. If you have an irrevocable trust, under most circumstances, it's like you don't have a trust. A revocable trust is a placeholder until it becomes irrevocable, typically after your death in what's called a pour-over will. And the will just says, all my stuff goes into the trust, and then the trust and the trustee handle what happens with it, and there's no probate. If all your stuff is in a business, then your business will have bylaws or an operating agreement or some governing document that will explain what happens upon your death, and that will decide the control of your assets. Next one, pay on death transfer. Those are common. Pay on death transfer is typically with a bank account, and it's like selecting the beneficiary for a life insurance policy. They also have these on retirement accounts and things of that nature. And so you avoid probate by telling the financial institution who has the account that as soon as somebody proffers your death certificate to them, that they're to pay those funds out to the laundry list of people. Gifts of assets using tax planning tools. So again, I'm not going to get into the tax planning issue of that. I'm not really qualified. But I will say that inter vivos gifts that you provide while you're alive, are ways to avoid probate because you're getting rid of the property while you're still there to decide what happens to it. But there are ways that you can engage in gift giving that will not function correctly. So, for example, typically when you're giving a gift, the recipient is getting whatever you're giving them for less than its fair market value. And when you do that, under certain circumstances, a creditor can claw that back. It's called a fraudulent transfer. And this would apply to putting things in trust as well. And it goes back to the thing I said, really one of the very first things I said, which is have a plan and then execute it. Because, for instance, if you had some terrible economic thing happen to you and you had to go bankrupt, if you put a lot of things in your trust, but it wasn't far enough in the past, even if it was an irrevocable trust, none of that stuff is protected. It's just, as far as the bankruptcy trustee is concerned, it's like you don't have a trust at all. So it's important, particularly with trust, but it's true with all of these vehicles, that you don't wait around to get started on it, because a 7-year-old trust is much more secure than a year-old trust. So a trust, what is a trust? A trust is kind of like an entity. It doesn't really work exactly the same as a business, but in the eyes of the law, it's like a third person. And it's just like a business is run by the people who manage it, or a board of directors. A trust is run by a trustee, and the trust has to be run in accordance with the rules of the trust. If you read one, it would look a lot like bylaws or a contract. So to have a trust, you need someone who's called a settlor. You need a corpus, and that's the body of the trust. You need a trustee and a beneficiary. So you have to have somebody who puts stuff into the trust. You have to have somebody who's going to be a benefactor of those materials, and you have to have somebody who's going to run the show. And the person who puts the materials in is called a settlor, which is weird legal jargon for the person who settled those assets. How did he settle them? Put them into the trust. When they're in the trust, you almost have to deal with the trust like it's a person. You come to the trustee and say, "Hello, Mr. Trust, can I have some money out of my trust, please?" And the trustee will look at the trust instrument and see what the rules are about distributing funds to that particular person. And then it ends with this a note that I went into a slide early about irrevocable versus revocable trusts. And those are the broad categories, and you have to be aware of that. Revocable trusts, you have ultimate control, but you have no protection. Irrevocable trusts, you have lots of protection, but you don't have any control, because you now have to, even if you're the settlor and you put the stuff in the trust and you make your spouse or your kids or both beneficiaries, and you become the trustee, you still have to manage the trust according to the rules that you set up in advance. Let's see what she has on revocable and irrevocable. All right, so here's an example. Husband and wife with 2 kids, they're minors. They own a medical center set up as an LLC. Is that a typo?
Probably a typo.
Looks like it.
I'm thinking so. Well, they have all kinds of partnerships that have extra letters, but I've never heard of LLC with an extra L. But we'll go with typo on that. So dad works, mom's a wife, a stay-at-home mom. Husband's in partnership with another doctor, and they have no operating agreement. So the first thing I'll tell you is have an operating agreement, even if there's only one of you. If there's more than one of you, if there's only 2 of you, do not have a 50-50 operating agreement. I litigate these fairly routinely. Somebody's got to be able to be the decision maker. And if you have a situation where you have an even number of owners and it's possible to be deadlocked because the ownership is divided evenly, then you can lose your business involuntarily, if the business is unable to move because of that deadlock, someone can ask a court to dissolve the company, and courts often will. So in this example, husband who's in his partnership with another doctor and no operating agreement dies in a car accident and doesn't have an estate plan. He signed the checks at the medical center for payroll, took care of all the bookkeeping and the business records, and did the same thing at home. The partner, who's now the only surviving person, was not a signatory on the business banking accounts. The wife was a joint owner of the personal checking account, but no other accounts, including 2 investment accounts. The wife and children are named as beneficiaries on a small life insurance policy. So in this problem, lawyers call this issue spotting. What are the issues here? And so she asked the questions here, what happens to the bank account? So if we flip back to the example again. So here it says that there's a bank account for the business and there's a joint personal account. So on the joint personal account, it's not a problem. The spouse simply remains on the account, and all the funds in the account, she can do whatever she wants with. However, when it comes to the business account, most banks will not allow you to open a business account for an LLC if you don't provide them with a copy of the operating agreement. But if the personal banker who sets the account up gets sloppy and allows you to do that, then you end up in this situation where the person who's the named person on the account, when they kick the bucket, this medical center has no access to its funds because the bank is not going to let the other partner have any access to that account. So you're going to have to open up a probate and get the court to see that account has to be opened up for the business. You also have a problem with well, let's go to the other slide and look at the other bullet points. I don't want to steal the thunder. So there's this partnership. Now, I don't like to use the word partnership unless legally we're talking about a partnership. We're talking about an LLC here. But there's this question, what happens to the LLC now that one of the 2 doctors has died? One of the things that I would look for is what that does under some circumstances. And I apologize now because I've been digging around the laws of another state. In some states, if one of the members of an LLC dies, the LLC, if it doesn't have an operating agreement, is dissolved immediately, just like that. You don't have one anymore. Off the top of my head, I don't think that's the fact in Oklahoma. However, we have this medical center, and mom now owns the other half of it because there's no operating agreement. If she wants to stay as an owner of the medical center, if the partner, the other LLC member, is not willing to buy her out or she's not willing to sell, that's where you are. And an operating agreement is a way that you can protect that. Often it's worked with life insurance or key man insurance or both, so that there's a way for one partner to ensure that the surviving spouse of the other can get bought out in a timely fashion without taking the business down with it. Depending on what your cash flow is like. All right, let's see what the 3rd bullet point is. Business operations. We already discussed that a little bit, and it's payroll is part of business operations. With no access to the business account, you're only going to be able to pay bills and make payroll off of money that you've taken in since your partner was deceased and placed into the other account. When we're talking about medical, you're going to have problems also with all of your Medicare numbers and insurance contracts and where they're paying into. So this happens. It doesn't happen so much in medical practice. I've seen this happen with CPAs, and I've seen it happen with construction businesses. So it's very important that that you have solutions for all of these problems. And the number one reason that a business goes under typically is lack of capital. You'll have no access to capital for 1 week to 6 months if you have to go through probate. Wife and children. So we know on the bank account, there's a pay on death certificate. It's a joint account rather, so she gets that. There's a small life insurance policy, so she gets, she's the beneficiary there. When they say a small life insurance policy, I suspect that that would be the kind of policy that covers burial expenses only. That kind of policy comes from backwards thinking, and Isaiah will get into that if he gets into life insurance, but I'll put my 2 cents in here. Life insurance is not for you because you're going to be dead. It's for everybody else. So if you die and all your family has is enough money for your casket and a hole in the ground, then your life insurance is not really doing its job. When we come down to living expenses, of course, the wife has now a half interest in the business, but the business has no access to its capital. And the life insurance policy is too small, so she's got her cash on hand, and that's it. So Mrs. Doctor is not in a good place here. And the point of all this, of course, is to explain to you why you need to do asset planning. People don't like life insurance, and they don't like timeshares and all the things that people buy that they're never going to use. But many of these things are things that the penalty for not having them, if you do need them, is substantial. Why will the IRS care what happens? Well, for inter vivos gifts, there's a limit before you start paying taxes. For most things that happen in probate, there are a lot of tax penalties. And I'm going to have to leave the rest of that to Isaiah and or next time when Lacey can be here. And with that, I will turn it over to Isaiah. I can tell you that my mother was in the same industry, and all those letters that come after his name were a hard one.
Thanks, Howard. Yeah, what Howard was talking about are a lot of issues that everyone has. And now we're going to start talking about issues as you continue to build your wealth, even more issues that you have. What are some things that you can be doing to make sure you protect your assets, to make sure that you don't pay too much in taxes or income taxes, estate taxes, things like that. So we'll talk about that a little bit. And Howard mentioned, life insurance is sometimes a tool that can be used in financial planning. And I'm going to touch on that a little bit. I see some problems sometimes with the ownership of those policies. So we'll kind of bring that up a little bit. Also, wanted to kind of make this more of an interactive type meeting today in terms of, giving you something to kind of think about as you get off the webinar. And all the things that Howard talked about, that I'm going to talk about, all these legal issues are state specific. And so to get state specific answers, we are happy to kind of do a free analysis for you on your estate plan and also on your income plan, things like that. And so I've got a questionnaire that I put into the chat. There's a questionnaire in there. So if you want to complete the questionnaire, email it back to us. The email's on the last page. We're happy to do that free analysis for you and kind of give you some specifics in your own home state. So some of the things that, can be concerning as far as asset protection, Howard touched on this a little bit, but, as a physician, kind of what we talk about is you don't really have to do anything wrong to get sued. It's kind of, you're just target number one, typically when it comes to, lawsuits, people like Howard, when they're looking to, sue folks. And some unforeseen medical costs can happen, other things like that. So it's a good idea to do some planning. There are some specific strategies that we can use here. And again, it's state specific. So I encourage you to fill out the questionnaire so we can kind of give you a little bit of advice there. But one thing you can do is maximize your qualified retirement plans. If you have a 401k plan, 403b plan, 457, those kind of things. You can put money in those. Depending upon the state, you can get a lot of asset protection there. And irrevocable trusts, Howard talked about revocable trust, which is kind of the foundation of an estate plan. Revocable trusts do not give you asset protection, but irrevocable do. And Howard mentioned that it's kind of harder to get access if you create an irrevocable trust as far as for yourself. However, there are some strategies where we use with our clients to make sure you have access to those assets if you end up needing them. And just talking about a few statutory protections in the state of Oklahoma, that's where we're home officed in. Homestead exemption is something that is a big deal. Most states have some kind of homestead exemption, which means that your primary home where you live, in Oklahoma, it's an unlimited exemption. You know, if you have a humongous house, then it's all protected from predators. Other states don't have as much protection, but that's something to look into. So if you haven't filed for homestead exemption, make sure to do that on your home. I already mentioned retirement plans can be another place to give you some asset protection. Life insurance, cash values, death benefit, annuities, things like that. In Oklahoma, all the money in those types of products are 100% protected from predators. In Texas as well, depending upon the state, it can be different for you. But if you fill out that questionnaire for us, we can give you some specifics on your state. And then 529 plans, college savings plans, a lot of times are protected from predators and also can be out of your taxable estate and avoid estate taxes when you die. So just to give you kind of a quick update on estate taxes. So depending upon the state, there are federal estate taxes potential that you could pay. There are state estate taxes you could pay. There are inheritance state taxes you could pay. Of course, everybody knows about income taxes. We all deal with that, right? Federal taxes. Some states have a income tax as well. So just to give an update on the estate tax piece of things, right now, if you have almost $13 million, you don't really have to worry about estate taxes. But in 2026, a lot of the tax benefits that came into effect, when the Trump administration kind of was in place, will expire. So in 2026, the federal exemption will be cut in half. So right now, you can leave almost $13 million to your family without any estate taxes, federal estate taxes. In 2026, it automatically will be cut in half. So let's say that a couple has $13 million together, that could be a problem as far as owing some estate taxes when you're gone. So some planning needs to be done. So if you're anywhere near that, we think that anybody that has, $5, $6, $7 million probably needs to start doing some of this advanced type planning to prepare for that, to avoid the 40% haircut, which is estate taxes when you die. Okay, and so this is another example to give you an idea of a higher net worth type family. This is their balance sheet. You can see they have a family cabin, a commercial building, some retirement plans. And one thing I wanted to point out is they have a life insurance plan, 2 life insurance plans with $5.5 million. So most people know that life insurance is income tax free when it's paid out. So life insurance, you can build money in it on a tax-free basis, and then when you die, it goes to your beneficiaries tax-free on an income tax basis, but it is not estate tax-free unless it's out of your taxable estate, which means you have to do some kind of irrevocable trust planning to get it moved out of your taxable estate. And this is something we see all the time. People look at their estate and they see, oh, I've got $8 million. No big deal, right? I'm under the exemption. I'm good. As a couple, we're under that $13 million. No big deal. But they forgot about the life insurance policy. And if the life insurance policy is inside their taxable estate because no planning was done, then they're going to have to pay estate taxes on it. So people don't think about that. They miss that a lot. And so this is kind of looking out into the future in the year 2041, assuming that this couple's estate grows by 5%. This would be a smart way to plan for estate taxes. You can see over here on the far left that we would put the life insurance into an irrevocable trust. That, as Howard talked about, an irrevocable trust will avoid estate taxes. And so that money goes out of their taxable estate directly to the heirs. The things that are still inside their taxable estate, you can see there, you can't really get, they aren't out, they're inside. And this is actually a couple that's in a second marriage. And so for asset protection purposes and protecting money for the kids of the first marriage is, typically splitting up the money into a bypass trust, which is the purpose of that is to make sure that the credit of the first spouse is preserved, and then the marital trust for the surviving spouse, would be another place to put that. And a lot of times we would use a Q-tip trust to protect the kids of that first marriage. And you can see how it flows through. And down here on the far right in the bottom, there is a $4.3 million estate tax bill when both of these people die. $4.3 million. And you know how much worse that would have been if that life insurance policy was not placed outside their estate? It'd be a lot worse. And so even with the life insurance being out of the state, this couple owes $4.3 million in estate taxes and $800,000 in income taxes. Okay, but again, if they wouldn't have put the life insurance in an irrevocable trust, it'd be even worse. So that's kind of a low-hanging fruit type item. I see a lot of folks that have not put that life insurance in outside their taxable estate. That's something to be aware of. And I'm going to bring Howard back in here to kind of close this out a little bit.
So I have a question first, Isaiah. Thank
Sure.
you, Howard, and thank you, Isaiah. So we first, just before you move on, can I place term life insurance in irrevocable trust also?
You can.
Does it have to be a type of life insurance, or it's any life insurance policy?
You can, but that life insurance, if it's term, may or may not be available when you die, and so you can, but it may or may not be there. You typically we see permanent life insurance in those, but we do have clients that put their term insurance in those trusts as well. But again, it may be something where you have to, change the policy over later on to make sure it's still there.
Okay.
Yeah, but you can.
Okay, thanks. Go ahead.
Yeah, good question.
Howard.
So even though I'm best known as a guy who sues other people, I do a fair amount of defense and transactional work. I was a business guy for over 20 years before I was a lawyer. Most of the defense and transactional work that I do today is for clients that I've gotten doing other kinds of work. And so many of these kinds of things I've been exposed to. The wealthiest clients that I have pretty much are all married and all have joint revocable living trusts. And many of them have irrevocable inter vivos trusts for their kids. And so there are a lot of clever things that you can do with this sort of thing, but it's very important that you have some kind of living trust. The trust primarily sets up your close family members first. The high net worth asset protection planning, utilize it. What is it? It's Isaiah, it's me. You have to go talk to a professional. The rules around all these things and trying to decide which one is appropriate for you is very complicated. Business succession plan. So not only that, but you've got to have, and I just did one of these for a large manufacturing company, but you've got to have an operating agreement for your LLC, and ideally you have a PLLC. And under a PLLC, particularly for medical practitioners, like our law firm's a PLLC, it's available for professionals. What it means is that one member of your LLC is not liable for the malpractice of another member. A very important thing for professionals, that kind of protection to have in the company. And that way it only falls to that particular person's liability policy. So when talking about a business succession plan, in this particular context, we're talking about what happens when you die or when your partners die. This buy-sale agreement, life insurance, use of trusts, etc. The most important thing I would say, if the idea is for the business to continue in operation after one of you dies, is to use life insurance to pay for the sale, because otherwise the business is going to be losing its income to make that purchase, and that can be a significant disruptor. Name pay on death beneficiaries on all accounts, sound advice. Move all assets out of your name. I don't know about all assets. You're going to go to the grocery store. Is this your can of corn? It is. You don't need to call your experts and have them put the can of corn in your trust. But certainly everything of value, everything that's durable, and everything you care about. And keep in mind that those things aren't always the same. There are plenty of things that are not valuable that may or may not be durable, and yet you care about what happens to them. And that's the issue of heirlooms. Communicate with your spouse and your business partner about banking and business records. You should do more than that, right? People don't like to talk about this stuff because it's uncomfortable to talk about your own demise, because we don't like to talk about what happens when we have no control over things, and because by definition, we're not going to be around when all this stuff happens. But you have to develop that level of comfort so you can have these open conversations and make sure that your business partners and your spouse or whoever are the important family members, the movers and the shakers with the same last name, so that everybody knows what's to do and you have a plan that makes sense. It's fair.
Okay.
Those are all our comments. If anybody has any questions.
Yes.
Some
So
chats.
since there's not a lot of people, so you can unmute yourself and ask a question. And we still have about 10 minutes. I have a few questions I can ask in the meantime. So there is someone asked this question prior. How can I protect my personal asset from liability arising from my medical practice? I know you probably touched about it a little bit, but can you just expand on that?
I have clients that ask that question. I don't do medical malpractice cases unless liability is in the bag and we're just talking about damages, because I also do personal injury litigation and I don't want doctors to be mad at me. Nevertheless, accidents happen and people will disagree about what your liability is. It's unlikely that you will never have at least a scare of a malpractice lawsuit against you. I think, absent catastrophic damages and just very bad facts on the negligence side, they sound worse than they typically are, and they're usually resolved by the insurer. But your insurance can be swamped. The insurer can think that, maybe you're not covered for this loss. Lots of things can come at you. One of the first things you can do is if you are in a small business, right? We have two ways to look at this. One is you're a doctor who works in a large hospital and you're an employee there, and your situation there is different than if you're one of the owners of a small practice. So, for instance, if you're an owner, then one of the first things you can do is have a PLLC, because number one, your whole practice can be in danger if another member of the LLC is the one who's being sued for the malpractice. The next thing you can do is you can make sure that you have enough insurance to cover you. And so that's going to depend on who your patients are, right? If I'm a doctor and you guys are my patients, then I need to have a much higher policy than if I serve, poor people at a clinic. And the reason why is because if I cause one of you guys to die through my medical malpractice, your future earnings capacity is something that I have to be able to make up. So insurance is by far and away the best things you can do to protect your assets. After that, it gets into all of these sort of strategies for putting your assets out of harm's way, and those are tailored normally. So you would have to go and see someone like Lacey or someone like Isaiah to work out what's best for you in your situation. But doing nothing is the worst thing.
And some states have not very good asset protection laws. I mean, that definitely varies. And The easiest way, if you have life insurance, cash value life insurance, or you have an annuity and you live in a state that has good asset protection laws for those kind of vehicles, then that's easy because that money is accessible. You don't have to do a bunch of fancy trust planning or anything like that. You just take out an insurance policy and put money into it, or an annuity and put money into it. So definitely checking to see, what your asset protection laws are like in terms of, your state and insurance type accounts. And, of course, qualified plans like 401ks and such, real easy. You can put money in there and that's protected in a lot of states.
Okay. We have Chukwudi. Go ahead.
Okay. Yeah. Thank you, guys, for really making our time to educate us. I've been personally into a couple of, people that have talked about this, having a trust, but it's just about, I know we're going to have your contact at the end of this lecture, but it's just about where to start, you understand? Because especially the states that have like the tort laws, like I practice in New Mexico, and we have a tort law. So meaning that there's really, there's a huge amount you pay if you have a lawsuit, against a practice. So it is something that I've heard, but making that step to really get a trust is very important. And then you mentioned something about the PLLC. Is another concept that I will be very interested to explore, because clinic has different doctors, so you want to make sure that everybody have his own shell, that if something happens to one of the doctors, it doesn't affect the whole practice. So these are the areas that I'm really very much interested in, more of that next step. We've talked about it, have all the information. How do we start? So if I want to do that, we're going to get your contact off stage, and we'll explore a little bit more on how our states, my state, how it is different in New Mexico, how we can get those things set up. Is that correct?
Yes, yeah. So if there's that questionnaire on the chat that I put in there. If you can fill that out, we will get back to you, and we will do kind of a free analysis and help you understand in your state, what's the best way to protect against creditors. So yeah, we're happy to do that for you and free of charge.
Okay, so this has to be filled manual. Oh, it's not a digital. Okay, I have to print it out and fill it manually, right?
Yeah, it's or if you have Adobe Pro, you can type into it. Either way, yeah, it's not a digital deal.
Okay.
I can send you a digital copy of that though. I can find one of those.
Yeah, the digital. I'll send you. I'll put my email here. I think it's not the better just to get something digital.
I'll send out a digital copy to you.
Okay.
I think they have the website. They have their cell phone, and you can also ask in the group. I'll link you with them, because I've worked with Lacey, who is part of this whole team. And she helped me with promissory notes for my lending part of my business. And I definitely trust the team. So that's why, we're inviting them today to kind of educate us. So we have a question here from Aaron. So what umbrella insurance do you recommend? So, I personally do, have umbrella insurance. Most people say you should at least have enough of, like, for your asset. Let's say your asset is $2 million. You should have at least $2 million of umbrella insurance. And they're very cheap. I think it was like $30-something per month or something. It was really cheap. So, to add more, it's not too bad. In terms of who to use, I'm going to let Isaiah answer later. But I used my company that I already use for my car insurance, and they offer umbrella insurance. So that's what I use. But I'll let Isaiah chime in on it.
No, that was great advice there. And kind of what Howard was saying is insurance is your first line of defense. So really buying as much umbrella coverage as you can qualify for is probably good as a doctor. Again, you guys get sued a lot for no reason. And,
Hey, now.
but anyway, it does kind of fit with your car and your homeowner's policy. So you have to increase the limits of liability on those first. And so, yes, definitely call whoever does your car insurance and your homeowner's insurance and just ask, how much of an umbrella coverage could I get? What does that look like? And it's pennies. It's so cheap. You should definitely have as much as you can get.
I'll add to that, rather than having an umbrella policy that's equal in value to your assets, your asset portfolio, I would say that you should look at what the potential of your risk is. So there are the AMA itself has done studies and can tell you which specialties have higher risks of being sued, higher risks of the lawsuits being successful, and what kind of payouts you get. The OBGYN malpractice coverage is more expensive because everybody thinks if something's wrong with their baby, it's your fault, not theirs. So you should look at things like that and try and assess what's the worst thing that could happen to me and insure for that.
Okay, thanks, Howard. We have another one. Is it advisable to invest with LLC instead of under individual names? And also, do you work with investors?
Yeah, so I definitely think it is a good idea. If you invest in your name, then there's no creditor protection whatsoever. If you invest in an IRA or in a 401k, those kind of things, and usually the doctors we work with max out those plans first. You get the asset protection, you get tax benefits, things like that. So definitely max those plans out. And then after that, yes, it is a good idea to consider, starting an investment LLC. And Howard will tell you that, there's no guarantee that if you did get sued, that'll hold up in court, but it's separating some liability from you. So, Howard, you want to talk about that a little bit more?
So generally, I prefer LLCs to corporations. I haven't yet found a state where that did it differently. So in every state that I've looked at, if you have a stock certificate or you own stock, whether it's certificated or not, that stock is personal property. And so that means just like your cat, just like a mouse, just like your car, the creditor can take it. So if you've got a corporation and you've got your business inside that corporation or your investment vehicles inside that corporation, and you get in a terrible car wreck and it swamps your insurance, then they can take your shares. And as many shares as the court determines would be equitable to make them whole. So LLCs, particularly, so there's two kinds of states for all of these kinds of laws, for corporate law and LLC law, and you have model statute states and you have Delaware states. I'm in Oklahoma and we follow Delaware. So typically, whatever happens in Delaware, it's going to happen here, because when it happens here, they'll go, well, let's look and see what Delaware is doing. And it will have already happened in Delaware because we're usually about 2 years behind them. In Delaware states, I don't know of one yet where your ownership interest in the LLC can be taken from you. So it might be in some way defined as personal property, but particularly in Oklahoma, if you get sued, you have this car accident, your insurance gets swamped, and your investment vehicle is in an LLC, they cannot physically take your LLC ownership from you like they could with a corporation. Instead, what they would do is they would get something called a charging order, and that's an order from the court saying, dear LLC, don't pay Isaiah until you've paid Howard. And that's the worst that can happen. If Isaiah were an employee as well, then I could garnish his paycheck along with a charging order, because they're they're two different vehicles for capturing that money. But LLCs are generally more robust than corporations for asset protection.
So thanks, Howard and Isaiah. I'm actually going to chime in here. I'm not sure if you can unmute yourself. I want to clarify your question. If you're talking about syndication also, or just regular, investments like, taxable account. Because with syndications that we do, you already are going to be investing into an LLC. Oftentimes we have multiple LLC. Sometimes we have a holding company, then we have the investor LLC, and then the investor LLC goes into the holding LLC. So there's most at least one or two LLC layers between your name, and rarely will people be able to easily find your name in many of these syndication. I'm sure they can find it, but like you said, they're going to write a letter to, do not pay him his distribution. But there's
thanks for clarifying.
Go ahead.
Yeah, thanks for clarifying, Bayo. Yeah, that was part of what I was asking, but the way you stated is definitely very clear. The other component is the one they also answered in terms of different states and how it's applicable. But yeah, that was my curiosity in terms of investments, especially if you're investing as an LP. I think that part is limited. But let's say if someone has vested a GP position, let's say they have a 5% GP in a certain syndication. I was curious to see is there any benefits to investing with an LLC into that syndication with that GP position, or would it be covered under the LLC that the syndication was initially started with? But I think based on what you said, it clarifies it.
I'm going to say what I do. I put my Dr. BDZ LLC goes into all the syndications. But when I do private, like limited partners, sometimes I use my name. Sometimes I use my wife's name. So it just depends. So, but for GP, and the reason why I do that is I wanted to get the reps, right? I want my wife and our LLC has the partnership, me and my wife on it, so that my wife is the manager. So it allows us to do, material participation, right, as a GP. And then you can use it for reps. The hours that you spend, even as a GP, can be used. So that's the reason why I use the LLC. Because many of these LLCs is so much LLCs. So what happens is my LLC goes into this manager LLC. This manager LLC goes into the holding company LLC. So it's multiple LLC. And then my LLC is inside another trust. So it's like so many layers, so that if people looking for you, they really have to be serious, to go after you.
The shell game definitely is a manner of defense, because if the lawyer's annoyed and bored or the client's difficult, then the attorney's probably going to turn away. So if you do have layers create a time factor and a work factor. And so it's going to slow down the other side, which can give you time to react or even further protect your assets. But it won't prevent them from finding you ultimately. I mean, it's going to cost $30 and I get papers from the Secretary of State. Now I find LMNOP company is owned by ABC LLC. So then I go and spend $30 and I get all the documents for ABC. ABC was signed by somebody who's with, PDQ. So and on and on. So it's 25 to $50 a crack and a couple of days each time that you try and go through this. But there can be value to it. I would also point out there's a cautionary tale. This is a real life tale by a retired OBGYN. And his practice was not in the United States, although he lives here now. but the practice where he was to put all of his assets into a trust and to have his wife be the trustee, and that way he could be a beneficiary. And his wife then died, and the trust was set up so that the daughter became the trustee, and the daughter won't pay him his maintenance. She's trying to make off with the whole thing, hopes he'll just die so she can inherit it. So when you do trust, make sure that your trust has the kinds of tools that are set up to protect the beneficiary from a wayward trustee.
Very, very, very cautionary, very important cautionary tale. I do have a question though. What do you think about using a bank as like an executor or your trustee? Using not an individual, but
Sure.
using a bank.
Well, I can tell you that, for instance, we had a wrongful death commercial trucking case, and there's a daughter. So the decedent is the mother, and almost all of the funds went to the daughter. And those go into locked accounts where you have to have a judge to play around with it. We have managed to put those in trust before, and then we use professional trust management, and we never have a problem.
Okay.
The fiduciary obligations of trustees in these circumstances are very, very high. So that's another thing is, in particular, if you're going to use professional trust management, you have to pay for that. They take a percent, of the money you make each year. And I would definitely shop that around. But what people do sometimes so that someone they're more comfortable with can be the trustee is they undermine all of the protections that a trust offers by taking away fiduciary obligations of the trustee. And my advice, and Isaiah's nodding, is don't do that. Okay, if you have to take all of those safety features out of your trust in order to have a trustee that you're comfortable with, then you have a trustee who's not qualified for the job, and you shouldn't pick that person.
Yeah, the most folks that enter that fiduciary role as a trustee aren't prepared for it. They don't have the education. They think about it. There's 4 or 5 children, and one of them's the trustee, and now basically the one who's the trustee is the piggy bank. They gets phone calls all the time. I want this. I want this. I want that. And so if you have a corporate trustee, if you use a bank officer, then that person's just a professional, and that's all they do. They can field those calls. They can work with the financial planner like us and make sure that that the trust isn't going to run out of money. And yeah, so it's definitely something to think about. We do have clients that have a family member, and this isn't a case where maybe we're not trying to do some advanced type stuff, and we don't necessarily have to have a corporate trustee. But if a family member is a CPA or something that is really good with money, really good with they can do the taxes, stuff like that, then yeah, let's make that person the trustee as long as it doesn't cause other issues, and then maybe put a corporate trustee as the contingent trustee or co-trustee, so that person, the family member who's the trustee, can always defer if maybe it's an overwhelming job for them. Maybe they're too busy in what they're doing. They can't handle the pressure. They can't handle all the work. They can defer to a bank officer. That's another way to plan it.
I'll point out, I like the idea of multiple trustees. It's very easy to have a conspiracy of one, very hard to have a conspiracy of two. Much less likely to get ripped off if there's more than one person looking at the books.
Absolutely.
Okay. Nice. So do anybody have any other questions? I know we already passed the time, so want to be respectful of everybody's time. And any question?
I think the last question I'll have is, in terms of resources, because I know that's a lot. And for some of us here, some of those, terms can be a little bit confusing. Do you have any recommendation for resources to help us educate and get us to par?
Yeah, we have a ton of what we call guideposts on our website. If you go to our website, edisonwealth.com, we call them guideposts. There's a bunch of short articles on advanced planning type concepts and also basic concepts that you can read, kind of a 3 or 4 page article. And our attorneys, put together all those documents and everything. And I can send that to you, bio, with the link if you'd like. That way you can kind of send it out to the group.
Yeah, definitely. I think
be careful what you find on. Be careful what you find on Google.
maybe ChatGPT might help too.
Yeah, be equally careful with Rocket Lawyer. I get at least one online generated legal document to litigate. I get one about every quarter.
I see.
Well, I do use Rocket Lawyer, so thank you.
Well, the biggest problem, there's 2 big problems with it, right? Many of the documents are fine. Either they fail to take advantage of local law, like I've seen the residential leases that they provide, and they leave out things that are very beneficial to landlords that you can get in Oklahoma. The other one is where people select a document and then either make very unlawyerly changes to it, or it's not really the document that they needed. And so it doesn't cover the circumstances that led to the litigation. You're a more sophisticated user than that, so I don't think you get in that trouble.
I mean, well, I basically use it mainly for rents, like lease agreements, and for people to sign documents, like so I use for promissory notes.
Sure.
But I have a lawyer already made the promissory note already.
Yeah.
But now I have to put it there so that they can have a place to sign. So just like a
lease. If you're a real estate investor, in the states where you invest, look and see if they have something like what we have, the Oklahoma Real Estate Commission. I know they have something like that in Texas. In Texas, residential sales are required to use the Texas Real Estate Commission documents. Here, we don't require people to use the OREC documents in sales, but they produce what are inherently very even-handed, fair documents from residential and commercial leases all the way up to sale of undeveloped land. And where those are available, then I would generally recommend the state agencies neutral documents.
Okay, there's wisdom in that. Well, thank you very much. Okay, so and we're gonna be sending the YouTube video to everyone once we clean it up, and also we're gonna have with PowerPoint so that you guys can contact either Isaiah, Howard, and we're gonna get Lacey. She agreed to come back at some point, and she can also give us a different angle of this kind of information again, maybe like last quarter. We give some time, and then it's going to be like a refresher. So thanks everyone, and thank you for your time.
Thanks for having me.
Okay, take care.
Yeah, thanks for having us. Have a great day.
Thank you so much, all guys, for coming. Thank you. Bye-bye.